See, okay, Sean's there.
Yeah.
I'm here.
All right. Good morning, everyone. Welcome to the Regulation and Discipline Committee. My name is Brandon Stallings, and I'll be chairing today. Lisa, can you please call roll?
Yes. Broughton,
Here.
Chan,
Here.
Cisneros,
Here.
De La Cruz,
Here.
Duran,
Here.
Ganag,
Here.
Pertula,
Here.
Saleg,
Here.
Shelby,
Present.
Stoll,
Present.
Tony,
Present.
and Stalin.
Here.
Okay, you have a quorum.
All right. Want to take this moment to make a call for public comment. So if you are online and would wish to address our committee, please indicate by raising your hand in the Zoom function, and which staff member is going to be monitoring that.
I will be calling on people and keeping track of the time.
All right. I think we'll try and stick with a 3-minute time frame just to keep everything moving along. So ask that any public commenters please respect that. Dag, do you see anybody who's raising their hand to make public comment?
Do not.
All right, going once, going twice. All right, sold. Next is the chair's oral report. And so this is my last update to RAD as chair. So I wanted to take this opportunity to thank everyone who makes the work of RAD possible and to highlight some of the work that we've accomplished this year. Members of Regulation and Discipline Committee should be proud of the groundbreaking work that we have undertaken in the study of disparities in the discipline system and in the timely and tenacious pursuit of ways to promote equity and fairness in the discipline system through the implementation of many recommendations from Professor Robertson. Some of these reforms include the archiving of old complaints, reworking the notice that self-represented litigants receive that highlights the pitfalls of self-representation and the importance of seeking counsel. We have worked with State Bar Court on increasing the robustness of their self-help materials that are available online, and we will receive an update from State Bar Court later on in this agenda. State Bar Court is to be commended for taking on this important part of the initiative. Further recommendations have been studied and their potential implementation is being considered. The pursuit of these reforms would not be possible without the hard work of Professor Robertson and State Bar staff, specifically Dag McLeod and your team of consummate professionals. While not directly under the purview of RAD, the Civility Commission has finalized its report and will be presenting 4 recommendations to the California Lawyers Association. This is the first large-scale project that is being undertaken jointly by CLA and the bar, and we look forward to bringing CLA's recommendation to the board for further discussion and potential implementation. Vanessa Holton and her staff at OGC have taken a deep look at the Rule 2201 program, which is our conflict program. We are offering up potential reforms to further professionalize our conflict system, ensuring greater public protection, transparency, and consistency with policies and procedures implemented in OCTC. So thank you, Vanessa, for taking this challenge on and for your wisdom in guiding us through the process. Every challenge creates opportunities to learn and to improve, and this board and staff have exemplified this through the inward look we are taking at the discipline system, including through the ad hoc commission. Staff is to be commended for continuing the hard work of the State Bar in reviewing the over 12,000 complaints we receive on a yearly basis, onboarding new employees, reducing the backlog of the most serious cases, all while working in a hybrid manner, whether at home or in person, and all in the midst of a pandemic. These advancements would not have been possible without the leadership of Melanie Lawrence, our interim chief trial counsel. Melanie, you have done so much with the office in spite of the challenges these past couple of years have thrown at you. The work of you, your senior staff, including but not limited to Steve Moad, and everyone else in OCTC deserves to be recognized. A simple thank you will never suffice, but I will say it. Thank you for your leadership. The last thing I want to report on is the work of the Chief Trial Search Committee. 3 board members worked on this pursuit. And I wanted to thank Trustee Sowell and Chair Saleg for your thoughtfulness on this working group. The Council on Access and Fairness were gracious to allow us to utilize the expertise of 2 of their members during the search, Judge Kim and the incoming chair, Ryan Harrison. Staff members Donna Hershkowitz and Leah Wilson provided outstanding support and expertise during this process. The work of Valerie Harrison of Bob Murray and Associates was incredible. Through her hard work and recommendations of many members of this board, we fielded a well-qualified and competitive field of potential candidates. After an exhaustive process involving numerous interviews with the search committee and then the full board, we were happy to offer to George Cardona the appointment to the position of Chief Trial Counsel. He starts in the first part of October, and we look forward to him being offered up for confirmation so that OCTC can continue their important work. And last but not least, thank you to my Vice Chair, Highland Chin, Staffer Extraordinaire, Lisa Chavez, Dag, Melanie Lawrence, and Steve Moat. Thank you all for making the work of this committee possible. So that is my report, and we will move on to the consent. That's right. Ruben, I definitely, I would just take this moment maybe as a personal point of privilege to applaud the work of Melanie Lawrence and for her stepping in as interim Chief Trial Counsel. So if you all are so inclined, please join me in applauding.
Brandon, I want to thank you. I think as your remarks reflect, you are so gracious and so dedicated to our work, and we really appreciate you and look forward to you in your new elevated role.
Oh, it's going to be fun. Going to be a fun year. Looking forward to walking it with you guys.
Great.
All right, so on to consent agenda. Does anybody wish to pull our sole item off? That's a request for approval of San Diego County Bar Association proposed revisions to mandatory fee arb rules. All right, seeing none, is there a second?
I'll second it, Mr. Chair.
All right, second by incoming chair, Ruben Duran. Lisa, please take the roll.
Okay, Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Yes.
Ganag,
Yes.
Bertula,
Yes.
Saleg. Saleg. Okay. Shelby,
Aye.
Sowell,
Aye.
Tony,
Aye.
motion carries.
All right, thank you. On to business. First item is the Regulation and Discipline Committee 2021 Work Plan Review. And Lisa is going to be presenting on this. So Lisa, tell us how we did this past year.
Okay. Hi, good morning, everyone. So I'm going to report on the status of the work plan. The first slide here discusses the work that we successfully completed. First, this committee reviewed the annual discipline report. Also on the far right, we had a goal of staff leadership within RAD working with staff on ADR messaging. And we did that successfully and how to market the ADR. At the bottom left, this was an item where this committee asked staff to identify and prioritize remaining Robertson potential reforms. And staff presented a proposal to this committee in March, where we outlined all the reforms that we had not yet acted upon, and we made our recommendations on the path forward. And then finally on the right, we had a goal of sharing the discipline system statistical report on a regular basis. And so we do that. We do present that report to this committee at the same time that we present the overall state bar metrics report. This slide summarizes the work that's going to be completed at your next meeting in November. We plan on having at least one more office that's under RAD's purview present to this committee. Right now, we're thinking about asking Office of Professional Competence to give us a little bit of a deep dive into their preventative efforts. OCTC hiring and retention, that's a regular standing item for this committee. And so OCTC will be giving a presentation on this topic of how we're doing with regards to hiring and retention. And also you'll be hearing from an update from commission leaders of the ad hoc commission on the discipline system. And this is a really good time, in November, that will be a really great time to hear from those leaders, because at this point, this commission will be able to share out on the work of the subcommittees as well as the working groups moving forward. Okay, so that's our plan. And so far there's no items that are left that will not be not completed. Okay, does anyone have any questions?
Right, anybody have any questions or comments, things that they liked regarding the work plan of this past year, things that maybe we can offer up for next year, things you want to keep on? I mean, certainly we're going to have a fuller and more robust discussion down the road regarding that, but if anything hits members of the committee right now, I'll certainly bring it up. All right. Seeing none, we'll move on to item B, amendment to rule of procedure 2201. And this is a request to circulate for public comments. And we have Chris Andresen, Jeff Del Cerro, and Vanessa Holton reporting on this. So who would like to go first?
Carissa will oversee this.
All right.
Hi there. Thank you all. This is our proposal to make some revisions to Rule of Procedure 2201, which governs the appointment and authority of the Special Deputy Trial Counsel program. And this rule governs the handling of complaints, disciplinary complaints, in any event where the Chief Trial Counsel is recused. And it involves any of the individuals with close ties to the State Bar. So in this particular proposal, we have a series of amendments, most of which were presented back in July at our last meeting. And the reason that they are being represented here is sort of upon further review, we determined that a broader set of proposals and revisions needed to be included, and it made sense given the content that they be considered together. So in that sense, the proposals that were circulated for public comment back in July are not being brought back at this time for approval, but instead we would like the entire broader package of revisions to be circulated for public comment at this time and then be brought back in November. So the ones here are identified in the agenda item essentially by the ones that were proposed back in July. I'll go through those first and then discuss the additional ones that we are now proposing to be included in the rule. So the main one here is to relocate the authority provision where the SDTCs were permitted to stand in the shoes of the Chief Trial Counsel. We are proposing that that be revised to provide that authority is vested only in the SDTC administrator rather than the individual SDTCs. And this would be to ensure greater consistency in the prosecutorial decisions of these matters. And it also vests a little bit of additional supervision in the SDTC administrator. We also propose clarifying that the SDTCs as well as the administrator are subject to the oversight of the Regulation and Discipline Committee. It will remove provisions that would have previously permitted the Office of General Counsel to be designated to remove Special Deputy Trial Counsel or the administrator. Under this amended rule, only the chairperson of RAD will have the authority to remove the SDTCs. And one thing I would also like to note here, some concerns raised by the board chair is what would happen in the situation of a RAD chairperson who was themselves conflicted on a matter when it comes to removing an SDTC or the administrator. And under the current rule and as proposed, there is a provision for a designee. So in the event that the RAD chair could not act in a particular matter, there is a designee provision that would allow likely the vice chair to fill that role. The remaining revisions were simply intended to sort of update the rule to current practices, including that the administrator provides a full report to RAD. We've substituted the term track for monitor in relation to OGC's role in keeping an eye on these. It's really more of a tracking function rather than anything substantive. And then to move on to the additional revisions that upon reflection, we determined were going to be necessary as part of this greater rule package. The first proposal discussed regarding vesting the authority of the Chief Trial Counsel in solely the administrator results in increased supervisory responsibilities of the administrator. And so in practice, those added responsibilities to the administrator position may result in the need for certain other responsibilities of the administrator to be delegated to other qualified special deputy trial counsels. And the one that initially comes to mind is what we refer to as the intake functions, where the administrator does the initial review of a new complaint that is referred and determines whether it warrants investigation or can be closed on its face if it doesn't present sort of a colorable violation. So we've added throughout section C2 and C3 the term delegee, which would allow the administrator flexibility to assign these intake functions to another special deputy trial counsel. And that essentially, again, is to make sure that there is room within the administrator role for these additional supervisory responsibilities that come with the exclusive authority to stand in the shoes of the chief trial counsel. So those are the proposed amendments that were included in the item. We have one more that we are considering adding here, and this was a concern raised by the board chair that I will try to explain the concern and then our particular fix. So when we're looking at current rule 2201, there is nothing mentioned in here of what the procedure would be where the special deputy trial counsel administrator has a conflict. In practice, what has been done is those particular matters are to another SDTC that serves as a backup, and these would that particular SDTC would then have the authority and the powers of the administrator just in that particular matter where the administrator is recused or has a conflict. There is currently no specific provision in the current rule expresses that authority of a so-called backup administrator. And so adding a provision, it would be under section C, and then subsection 2. We could propose to add one more provision that would read, in the absence of the administrator, the powers and duties of the administrator shall be exercised by a backup administrator. So clarify that where the administrator is unable to act in a certain matter, the backup administrator would then have the same authority and the same duties of the administrator in that particular matter. And I apologize that this is not in the materials in front of you, and I'm happy to address any questions or concerns on that additional proposal.
All right. Thank you, Carissa. Does anybody have any questions for Carissa or staff on this? Yes, Mr. Tony.
Thank you. Just, could you remind me around how many cases a year are handled by the special deputy trial counsel?
It has varied significantly in the past few years, but I would say it's somewhere in the range of 1 to 200.
Perfect. Thank you. That's good enough for me. I appreciate it.
Sure.
All right, any other questions? All right, I did want to note a couple of things just in the discussion of these issues with chair and vice chair. I think one of the themes that really presented itself was that this is a further professionalization of the 2201 program, really brings our 2201 standards in alignment with reforms that we've implemented in the Office of Chief Trial Counsel. So I think this is a really important step, and want to applaud staff for having the foresight in taking this on, and also really helping to define RAD's overview and what we need to do as board members in overseeing this program. So I think it really does help to distinguish some of those things and give us a little bit more meat to sink our teeth into. Another thing that I think was of note is that that RAD would have more of a role in setting the policy behind qualifications for SDTCs and the intake SDTC, but would not be involved in the selecting of the individual themselves. And so I just wanted, Chris, is that correct? Is that also your understanding?
That, I'm sorry, who would not be involved in the selection if they were recused?
Well, we would not be involved in the individual selection of the SDTCs or the intake person. We would.
Right. Right, Brandon, we did discuss that. That was a concern that was potentially raised, whether RAD would want any input in the selection of who the administrator could delegate those intake functions to. As the rule is proposed, it would certainly be an SDTC that was already appointed by RAD. And so in that way, RAD exercises a little bit of control over who would have that function. But as the rule is currently proposed, it would be a delegee chosen by the administrator.
I want to, for the benefit of the trustees, I just want to clarify that each special deputy trial counsel and the administrator, and we will be selecting a new one for the new year, is done by RAD or by the chairs on behalf of RAD. It's only in this conflict situation.
Correct. Great. Thanks for clarifying that, Vanessa. Thank you.
Brandon, Sean has his hand up.
Yes, Sean.
Yes, I'll move adoption of the item with the changes, with the two changes described by Carissa.
This is Jose. I'll second the motion.
All right, first by Sean, second by Jose. Any further discussion? All right, Lisa, please take the roll call.
Broughton. Broughton. Chen.
Yes.
Yes.
De La Cruz.
Yes.
Duran.
Yes.
Denag.
Yes.
Bertula.
Yes.
Saleh.
Yes.
Shelby.
Aye.
Soul.
Aye.
Tony.
Aye.
Motion carries.
All right. Thank you to everyone who was involved in the drafting of this and for your foresight in it. So thank you. Moving on to item C, the proposal to increase compensation for special deputy trial counsel and administrator. And Vanessa, show you and a Chris on this.
Correct. I'll present on this. Brad may recall that this proposal to increase compensation for the Special Deputy Trial Counsel was first discussed in July. And the board, the RAD, did not act on it at the time. So we have brought it back with a more fulsome discussion of the proposal. Just to summarize, the current Special Deputy Trial Counsels earn $100 an hour for their services, and the administrator earns $150 per hour. That has appeared to be too low a compensation. And so this proposal is to increase that hourly compensation to $250 for the SDTCs and $275 for the administrator. It's still not full market rate as the item lists, but it's intended to enhance recruitment and retention of quality and productive attorneys in those positions, and to align more fairly with the rate that's paid to the State Bar Court appointed counsel who practice in the same area, and we pay them $300 an hour. This amount that is not yet market rate still, though, recognizes that these two positions are in part a voluntary contribution to the attorney profession and to the State Bar. The financial impact of this is laid out in the fiscal personnel impact section of this item. And briefly, for the remainder of this year, the increase would require spending about $40,000 in excess of the budgeted amount, and future years would increase the budgeted levels by an estimated $65,000 annually, both of which are to be absorbed by the general fund. Two other aspects to this: we are proposing, a trustee suggested, and we think it's a great idea, to make this increase retroactive to May 1, when the counterparts in the State Bar Court appointees had got their $300 increased to $300 an hour. Also, in further effort to professionalize the program, OGC and Finance has noted that we've had some tracking and reconciling challenges around the charges. So we're going to work together to revise the invoice input procedure, how Oracle receives that information and aligns with our records. And so we're also suggesting in the proposal, the resolution, that RAD would undertake a 1-year post-implementation analysis to see how things are proceeding. So before I set forth the proposed resolution, are there any questions or comments about this? Okay. The resolution is that RAD approves a new hourly compensation rate of $250 for the Special Deputy Trial Counsel, and a new hourly compensation rate of $275 for the Special Deputy Trial Counsel Administrator, retroactive to May 1, 2021. And there's a further resolution that RAD, after 1 year of implementation of the new hourly compensation rates, review relevant data on the Rule 2201 program to determine whether any adjustments, including in the SDTC and administrator compensation structure and OCTC's referral of cases to the program, should be recommended.
All right, thank you, Vanessa. Any questions or discussion?
Brandon, this is Jose. I'll make the motion.
Great, thank you. Is there a second?
I'll second that, Mr. Chair.
All right, first by Jose, second by Ruben. Any other comments or discussion before we put it to a vote? All right, hearing none. Lisa, please take the roll call.
Broughton,
Yes.
Chen, Cisneros,
Aye.
De La Cruz,
Yes.
Duran. Duran. Ganal.
Here. Yes.
Duran is an aye.
Okay, thanks. Petula,
Yes.
Salik,
Yes.
Shelby. Shelby,
Aye.
thank you. Sol,
Aye.
Tony,
Aye.
motion carries.
All right, thank you, everyone, and Vanessa and your team for taking this on. So this is an important piece in our important 2201 work. So thank you so much. Next is item D, which is the RAD oversight of the Chief Trial Counsel. And so Leah,
Sure.
please take us through this.
So as we've heard this morning, and as you all are aware, we're preparing to onboard a new Chief Trial Counsel. Mr. Cardona begins October 4th. And I thought this was a good time to step back and revisit the oversight function or structure for the Chief Trial Counsel position. As you know, this is a position that reports directly to this committee, and it can be difficult for a committee to supervise an individual. And so in this agenda item, you have listed out the fairly, as I say, both broad and limited indicators of RAD's oversight responsibilities as currently articulated in the board book and in the RAD charter. So I'm making a proposal in this item to enhance this aspect of RAD's work. One, by formalizing their requirement to establish a performance plan for the position. So this would be prospectively looking ahead. What are the goals that you'd like to see the individual in the role achieve, as well as to continue your responsibilities vis-a-vis the performance evaluation. And then most significantly, I am suggesting that the RAD chair and vice chair take on a new responsibility for meeting quarterly with the Chief Trial Counsel. And I have worked with staff to draft a proposed dashboard for this check-in. And because of the fantastic skill leveling up that's gone on in Oriya, we will be preparing this dashboard in Power BI, so an online tool. But you can see here in your agenda item a mock-up of it in PDF format. And maybe Lisa, if you can put that up, and then I'll just open things up for questions.
Right now?
Yeah, go ahead. Thank you. So this dashboard is going to cover some key components that I think are important. And certainly when I think about how I supervise staff, these are some of the areas that I look to. And when you see that last bucket there on employee engagement, this is an area that I think has been quite lacking in terms of the oversight function or the relationship between RAD and the Chief Trial Counsel. So Lisa, if we could go to the first category, inventory and case. This is just high level information that of course is important. You do receive much of this or some of it via the metrics that are reported to you. The way this will be set up in Power BI will enable you to hit the chair and the vice chair to hit various buttons there on the left and look at the data in different ways. But essentially here, you'll be looking at total inventory of cases. You will look at cases by priority designation, as well as by complex designation. In the next agenda item, Doug will be talking to you about our new statutory ability and I think responsibility to begin designating cases as complex. So here the inventory will be able to be looked at in multiple ways, and you'll be able to assess the age of the inventory. Of course, we are still held to age standards for our inventory. If you can move to the next one. Then we're going to look at case clearance rate. So one, inventory is what, a snapshot of what the overall caseload for the office looks like. Case clearance, how effective are we at clearing cases, processing cases? And again, multiple different views of the data broken out by complex and non-complex cases, because there are now two different time frames statutorily associated with our case processing standards vis-a-vis these categories. You can go to the next one. The next couple of slides show you how the tool will be able to provide a drill down within OCTC to the team level. And I think, again, when stepping back and thinking about the way that I might supervise the position, that I think it's important that there is some exposure to how the various teams within OCTC, of course, only those that are doing similar work, are performing vis-a-vis one another. So these two slides reflect the fact that that data will be made available to the chair and vice chair of RAD. You can go forward, Lisa. And this is the same a team view at the case clearance data. Go forward. So now quality. Quality is, of course, very difficult for us to measure. We don't have very many metrics in this regard, but we have there on the top, the first three, or actually, I think all of these on this slide are ones that you have seen in your metrics report. How many cases are reopened by the complaint review unit within the Office of General Counsel. The random audit that's conducted biannually, there is a contract renewal request for you on your main board agenda regarding that random audit. But the random audit recommendations with respect to reopening cases will also be part of the dashboard, and the Walker petition. So these are cases where the Supreme Court indicates that the OCTC needs to modify its original course of action. So that is quality data. In addition, procedural fairness. You all are aware that we do survey complaining witnesses, trying to get not at whether or not they agree with the outcome of the process, but do they feel they were heard and whether or not the process was fair? And that's an important quality indicator. New, something that is not currently presented or provided to RAD, will be narrative feedback. So with respect to the complaining witness survey, we will provide a summary or all comments, depending on the volume that we receive, and feedback from the public. I do get quite a lot of communication from the public at various times about OCTC and various staff members, and this will be summarized and provided to the chair and the vice chair as well. If you could go to the last one, Lisa. Lastly, on employee engagement, and this data being provided to RAD leadership will be new. You do receive the report, I believe, on retention, as Lisa mentioned earlier. I think you're going to be receiving that in November. So certainly we need to look at retention and turnover, but also I will be providing information on our stay and exit interviews. We conducted the State Bar stay interviews with all new hires at 90 days of hire. This is a best practice designed to encourage folks to stay with the organization and to check in on their engagement with the organization. So the stay interview results for OCTC staff will be summarized and provided via this dashboard tool, as well as the exit interview feedback. We conduct exit interviews, and similarly, that information will be provided as well. And then we have a spot here for other staff feedback. We have at the State Bar an anonymous employee in email inbox. It's called Incognito. And I do receive quite a bit of feedback through Incognito. And again, I think it's important for the individual or committee that is supervising the Chief Trial Counsel to have the benefit of seeing at least a summary of what that feedback says. So those are the components of the dashboard. As you can see, we don't have any data here. The idea is to prepare the first one to cover the period October 1 through December 1, the fourth quarter of this year. And that will obviously be also the first quarter that Mr. Cardona is in place as the Chief Trial Counsel. I fully expect, hope, and anticipate that the RAD leadership will work with Mr. Cardona to finalize, refine, enhance, improve this dashboard. It should be viewed as an iterative living document. But nonetheless, it is my first take on key components. for this review process. So with that, Lisa, I think you can take it down. Happy to entertain any questions. This is an information item only. If you all are in agreement with the proposed structure outlined in the report for oversight, we will codify that structure in the board book and bring the board book revisions to the executive committee, I believe, for approval at the next board meeting.
Great. Thank you, Leah, for your thoughtfulness in this area. Do we have any questions or comments from board members? All right, I see a couple, Mr. Duran.
Thank you, Mr. Chair. Leah, thank you for this work. I think the timing, as you mentioned, is perfect. And it's clear that you put a lot of thought into some ways that the committee and the committee leadership can take a very active stance and approach towards the important work of the OCTC. So I think that's gonna help us demonstrate to the legislature and to the Supreme Court and others who really watch our work and our system that there's meaningful interaction and participation from the policymakers at this organization. I think that's important. So thank you for the work. I look forward to seeing what comes before the executive committee.
Ernie?
Ernie.
Thanks. Leah, I appreciate you bringing this forward as well. And I think it's a good mix of both quantitative and sort of qualitative measures. Couple questions though. One is, it seems awfully quick to me in that this final quarter of this year to try to measure performance, given the short tenure of when George would start, as well as with the holidays. And so I just wonder how what you think. Should we still just sort of leave it that way, but expect that, you know, it's kind of going to be a real feeling out period initially?
Absolutely. And really, this is, you know, the idea is that this dashboard would be created every quarter with data from the subsequent quarter. So really, the first dashboard would be created in January, the end of January, optimistically, for the period October through December of 2021. And I think it would be viewed, just as you indicate, as baseline data. I don't think it would be reviewed as anything else. And I also think it's important. It's a very difficult job, as you, I think, are all well aware. And there are many dynamics at play impacting the indicators on this dashboard. And so even if many of them are not going in the right direction for a certain period, I think the chair and the vice chair will have the understanding of the complexity. And so I don't even see that as something, you know, not necessarily a negative statement about the performance of any individual. It may highlight systematic reforms or improvements that are needed overall. So I would say the first quarter is baseline data, and on an ongoing basis, this is a tool for oversight and support and partnership, not just sort of a hammer, so to speak.
Got it. So my second question is, by adopting this item, does it sort of lock in the dashboard without this committee possibly having the opportunity to, is there some flexibility, I guess is what I'm asking, to add additional sort of valuable points, those sorts of things like that?
Yeah, absolutely. Because what I would modify the board book to reflect is really what you see in discussion, the discussion section of this agenda item 1, 2, and 3, basically referencing a quarterly check-in and some kind of a dashboard tool, not the specific components of the dashboard. Brad, you may choose to do that at some later date, but I do think we need to see how this actually works in action. And obviously George will need to have his imprint on the tool as well.
Very good. Thank you.
And I think, Arnie, to your point, certainly there can be a standing item in the work plan if RAD chooses to adopt that, to where there's that continual, maybe it's brought up on a semi-regular basis on the efficacy and of those numbers and how it's driving that RAD discussion. So great insight. All right, anybody else? Yes, Mr. Tony.
I really appreciate the time that Leah put into this proposal. And I think it's terrific. It's a great idea. It's I think it'll be supportive to George. And that's how I look at this, as a way to support his success. And so in saying that, I volunteer to serve on the committee as well.
All right, anything else? All right, thank you all for your insight and for your work on this. Leah, thank you.
Thank you.
All right, moving on to item E, which is update on plans to address the requirements contained in Senate Bill 211. We have Dag and Melanie Lawrence on this.
Good morning. I am making sure that Melanie has been promoted before we get underway here. There she is.
Good morning.
Good morning.
This item follows quite naturally from what Leah was just discussing. We're going to be talking about some data and some measures. It is also an informational item, but one that I also hope we have the opportunity to get some feedback and input from members of the Regulation and Discipline Committee on. This item is actually also a natural follow-up to an agenda item that was on the July meeting of the full Board of Trustees. On that agenda item, we sought the board's approval for case processing time standards that we had hoped would be incorporated into statute to replace the statutory backlog goal of 180 days. The board approved those standards. We brought them to the legislature and worked with legislative staff to see if they would accept those and incorporate them into statute. The legislature declined to do so, and what they did instead is the subject of this agenda item. We now have a mandate contained within the language of Senate Bill 211 to create standards, and I'm going to go through that mandate as part of this agenda item, and also solicit input again, as I mentioned, from members of the Regulation and Discipline Committee. The mandate contained within SB 211 is here in Business Professions Code 6094.5, states that the state bar shall propose case processing standards for competently, accurately, and timely resolving cases within the Office of Chief Trial Counsel. It goes on to say that the proposed case processing standards shall reflect the goal of resolving attorney discipline cases in a timely, effective, and efficient manner while having small backlogs of attorney discipline cases and best protecting the public. In addition to this language regarding the development of case processing standards, there's clarifying language regarding complex case designations, which we're going to discuss also. I'm going to lead off by talking about the case processing standards, and then Melanie's going to pick it up and talk about the complex case designation and the factors that might go into establishing criteria for what constitutes a complex case. In terms of the case processing standards, there are two things that I want to mention at the outset before we get into the actual dimensions of public protection that we have carved out, as well as the measures underneath each of those dimensions that we want to talk about. One issue is that any metrics or standards that you apply to trying to assess something, they need to be balanced. And we're certainly going to see that in terms of the different dimensions, and this is partly why it's so important to have multiple dimensions of this overarching concept of public protection that we can use for assessing how well we're doing. Obviously, if we have a factor, a dimension related to timeliness, we can't look at timeliness in isolation and exclusive from our goal of protecting the public. Obviously, we don't want cases that are processed fast if that means that we're sacrificing some other value within our goals of public protection. So this is one of the things I just wanted to note at the outset in terms of the need to balance these different factors. And the other item that I wanted to mention with regard to the measures that we're looking at today is I wanted to note that the legislature directs us to create standards. And what we have in a lot of the slides that I'm about to present and in the agenda item that is posted to the agenda, what we have is we have a lot of measures, we have a lot of data, but those aren't necessarily standards yet. And what I think is the critical piece of converting a measure or some piece of data into a standard is that it applies a target to the thing that you're looking at. So I just wanted to say that as we go through these different pieces of data that we have already looked at and considered, many of them you've already seen before. They're part of the annual discipline report. These are measures that are included in the discipline system statistical report that's presented to the Regulation and Discipline Committee. They're included in the state bar metrics. Some of them overlap with the measures that Leah was just talking about in her presentation. But what we really want to figure out wherever possible on some of these is what would the target be? And although we don't have the answer to this at this time, what we're really asking of members of the Regulation and Discipline Committee is we're asking whether you think that we've got the right dimensions. 3 of them are mandated by statute. There's a 4th that we've added, but is the 4th that we've added the right one? Does it make sense to you? We want to know whether you think that the measures make sense as well. Are these the right measures? Are we missing anything? Or are there any measures that we've included that we've been looking at that you don't really think make sense for proposing case processing standards? So with that, I'm going to move on to our 4 dimensions of public protection that we've broken out. As I mentioned, the first 3 of these are explicitly referenced in the statute, and they are timeliness, effectiveness, efficiency, and then the 4th that we've added in part because it matters, in part also because we've done a lot of work in this area. We spent a good part of the last 2 years looking at equity in the system in terms of disproportionate discipline, but also looking at whether the state bar can't be more proactive, can't address providing support for attorneys that would prevent misconduct in the first place, rather than exclusively focusing on the back end after misconduct has occurred. So I'm just simply going to go through these elements one by one, these dimensions of public protection, and lay out what we already have data on, and solicit your input on these before we then turn to the question of case complexity. In terms of the measures that reflect timeliness, these, again, have been culled from existing reports that we already have and work that we've already conducted. So we obviously have the backlog target, the 180-day backlog target that we have reported on many occasions. Obviously, if you can report it for 180 days, you could extend that time frame and report it for further longer periods or shorter periods. The case complexity issue also touches directly on the backlog target insofar as part of what's meaningful about the case complexity designation is that it allows for a longer time frame for case processing for cases that are designated as complaint. It allows for a 365-day target for complex cases. We also have the case disposition times within specified timeframes that we put forward at the July board meeting. We have targets related to decreasing the number of P1 cases in backlog for respondents with active licensees. Although this is not a specific target, we do have a target insofar as we're saying we want to decrease that number. This is something that we've developed and have included in the annual discipline report for a number of years now. We have a target of resolving 100% of the priority 2 cases within 100 days. And we also have some descriptive measures with regard to case disposition times. So I'm going to turn off my share right here and now just so that I can see you all. And I think this is a tricky kind of item to get into, but I would greatly appreciate any input with regard to those measures or anything that you think would be valuable for thinking about timeliness in terms of its impact on public protection.
How good? Oh, good. Okay, go ahead, Mark.
One, I think this makes a lot of sense. I really support the direction it's going. I'm going to make a comment I've made before, which has to do with the benchmarks for different time periods that we have existing. I like that there are different goals for different time periods. I think that's important. I think using 7 months as one of the time periods doesn't match up with 180 days. It makes it hard to determine how many of those are within the 180-day goal means something. And so it says 75% in 7 months, I believe, from what you put up. And if it's necessary to drop the number down to 70% to get to 6 months, I think that's better because it gives me, as a trustee, an easier way of being able to look at these and say, how closer we're getting. So that's just because 180 days is kind of in statute. To me, 6 months is closer. A day or two, I don't think it's closer than 7 months. So that's just something I'd like to add as it would be a helpful tool to interpret what's going on.
Thank you. That's helpful.
But I want to make sure we're being clear about the opportunity that we have in front of us with the bill. This bill allows us, the fee bill, to step away from the 180 days. We are really being asked to come up with a new standard. Timeliness has to be taken into account, but not with a specific day delimitation. And in a way, it's very difficult to do it. We've all been struggling with 180 days. It's not realistic. We can't meet it. It's very problematic. But when you step back and say, okay, basically the opportunity we have in the bill, okay, we hear you. So tell us what is reasonable, and keeping in mind the goals of public protection and keeping in mind the concept of timeliness, then we have to say, well, how do you define timeliness? So Mark, I don't know if what you're saying is you think the 180 days, irrespective of any legislative mandate, is an appropriate time frame. That is important feedback to have, because that would say, okay, we should still be working towards a general goal of resolving cases in 6 months. But I just wanted to make clear we do have the opportunity to move away from that now.
And I completely support that. I think we're in a situation where part of what's going to, I believe, increase the political chances and support the political support for this new reform is our ability to simultaneously understand that we're asking for new reforms. We can show what the results would be under that. I think until they are approved by the legislature, we also have the obligation to comply with the current statutory requirements and expectations. So that's all I'm saying, is that I think the more that we show our cooperation and that we're working as hard as we can in the current system, but that there's a better way. So we're going to have to, I'm just saying, we still have an obligation to the current system until a new system is adopted. And I think we have to have almost like 2 tracks. That's all I'm suggesting.
That makes
Any-
sense.
Any other comments on timeliness? Brandon, were you about to say something?
I was just going to ask if anybody else had any comments. All right, Doug, I think we go ahead and move on to the next portion then.
So here we have okay, I can scroll it, I can't arrow it. Okay, here we have measures already reported, already calculated related to effectiveness of the system. Here's where we see some of the overlap with the material that Leah just presented. Our complaint review unit regularly reviews cases on the request of a complaining witness when they believe that a closing decision by the Office of Chief Trial Counsel shouldn't have been made, that the Office of Chief Trial Counsel should have pursued the case further. That is just an inherent built-in mechanism for evaluating closing decisions. The Supreme Court provides yet another built-in opportunity to evaluate the closing decisions by reviewing Walker petitions. This is the review of the decision of the complaint review unit. And we have data on those. We already captured and already reported on it. I think that those are terrific measures. It really takes the adversarial nature of the system into account and says, well, if the decision's upheld, that's some indication that OCTC is getting it right. I don't list it here. Well, let me finish with percent of random audit reopens for substantive reasons. Same issues as the above. We have these audits that are conducted and recommendations related to reopens. What I don't list is the court process itself, and this is contained in the board agenda item, or the agenda item, but it's not in this slide. But the whether Office of Chief Trial Counsel wins a case or not is a similar indicator of whether Office of Chief Trial Counsel is being effective in its charging practices and in its prosecution. We could certainly calculate that. The recidivism metric is one that we've reported periodically. It looks at new complaints, new investigations, and new discipline against attorneys who have already been subject to discipline by the state bar. Recidivism is in quotes primarily because of these first elements looking at new complaints. We know that there are many complaints that are filed without merit, and we know that different practice types are more susceptible to complaints than others. So that's why recidivism is in quotes there. But we also believe that to the extent that we can manage expectations properly and possibly limit the number of complaints coming into the system, that would certainly alleviate some of the workload of the Office of Chief Trial Counsel and free up resources to investigate those cases where there is actual misconduct. And the final item that we have listed under measures that are available for evaluating effectiveness of the system are counts of the number of attorneys in priority one cases who are still eligible to practice law. So again, if there are anything that's missing, something that you think would be useful, anything on that list that's not particularly useful or that you would like us to consider as we move forward in proposing targets here.
All right, anybody have anything they wish to add?
Well, can I just ask, like, how would any of you define an effective discipline system? This is our opportunity to try to do that.
Anybody want
Mr.
to take a
Chair,
stab at that?
Yeah, I'll chime in, and I feel like we sort of touched on similar issues and topics in the past. One thing that sort of resonates with me is our ability or inability to identify trends, whether it's multiple complaints against an attorney or multiple types of complaints against more than one attorney, but we're talking about it in terms of the trust fund issues, for example. It's like, okay, how can we aggregate data to identify trends, and that patterns maybe is a better word. I'm assuming or hoping that that concept can work its way through some of the stuff that Dag just talked about. At least I think it'd be important to me.
I think, Ruben, to your point, it's important to be able to identify those trends, but also do so in a manner consistent with other reforms that we're taking on, such as the archiving of closed complaints, making sure that we're not using other extrajudicial data to drive some of these investigations. So I think that's also an important policy decision to make, or to have in the back of our mind, making sure that we're reaching a determination on the merits of each case alone, and not kind of aggregating all these cases in together and say, okay, we're going to make a filing decision because it fits this trend that we're seeing. So I think I don't think that we would do that, but it's certainly something to keep in mind with some of these other reforms we're taking on.
I would hope that maybe that speaks to the issue of balance that I mentioned at the outset, that one would want to take advantage of data that is in the system that allows you to identify patterns, and ideally to be even predictive in doing so. At the same time that you need to be careful about not taking into consideration irrelevant factors, or the closed complaints issue, where it's a complaint that's been closed without merit. If it doesn't have any value in terms of establishing a pattern of conduct, then it is appropriate to archive that and keep it out of sight. I noticed that Trustee Pertula has a hand raised.
Yeah, my question about timing, Dag. What are the expectations? Maybe I missed this. Are we supposed to be providing feedback, and in what is the timing? And I'm more curious, is George going to have an opportunity to participate in that?
Good question. The statute says that we need to propose these by next year. I think it even references October 31. We actually need it much sooner than that, because I think we're going to need to be shopping these with the legislature by the spring, I think at the latest. So we have, it's not immediate, but it's going to need to be worked up, and then the new incoming chief trial counsel is going to need to have an opportunity to weigh in on them.
Yeah, the idea is that we would have a draft proposal in time for the next state audit of the discipline system, which we know is coming in the spring, so they can review it, because the fee bill does contemplate that the auditor will review these standards. So we're trying to kind of accelerate the process so that if the standards are approved, they can be reflected in the 2023 fee bill.
Well, something
So
I think.
Go for it, Josh.
Something I've personally struggled with on the 180-day. I appreciated the fact that we have an opportunity here to describe and explain and come up with maybe a time frame and a different system that would work better. One thing I've struggled with on the 180-day is, sometimes it's about resources for us, but then we add resources. I can't tell exactly how many of those are impacting it or not. I know some of the spots were not all hired. Then if it wasn't just the resources, what else and what is the right number of days or timeframes? I couldn't, sitting here, weigh in and feel like I have a good grasp on that.
Yeah, I think it's fair. Certainly the audit pointed out that our case processing timelines have extended, although we have received increased funding. And although there are ways to explain that and all the positions weren't filled, it is certainly, borrowing from Melanie, an optics and a narrative problem at a minimum. So I think that those are some of our realities, and why this is really challenging, actually, to be given the opportunity to come up with something that we think will work, absent that sort of confine of the 180 days. Then you've got to figure out, well, what is it? So, Arnie? Sorry, Brandon.
No. Yeah. I'm not seeing the hands here. So yeah, Arnie, go ahead.
So I have a couple questions about implementation that I think I'll save because there's others with their hand up until we get maybe towards the end of this item. But I do have a question that goes back to I guess Leah, your question about effectiveness. How do we think about effectiveness? And this item is about the effectiveness of the current attorney discipline review system and our internal effectiveness on that system, correct?
I don't think I would limit it to internal. I mean, I think it's, and what we tried to do conceptually was to link it back to public protection. This is the mission of the State Bar.
Okay, and so in that regard, Dag, I wonder if there is also, if we think about effectiveness, if we could go more upstream, and upstream meaning, reducing the number of cases that actually get into the system or the need for discipline because of trainings, because of public outreach, because of other sorts of processes or practices or procedures that we implement that might impact the system more upstream, so you don't get to a point of discipline. And clearly there will be some need for a discipline system. I don't expect that ever to go away, but could another measure be this more upstream measure? We conducted X number of trainings. We conducted this type of outreach, those sorts of things like that may have also impacted the number of cases that actually came into the system.
I think that's a great suggestion. And though I think difficult to capture, I could imagine if we were able to reduce the number of complaints that come in that are simply not related to misconduct. And I think that the education of the consumer and sort of inoculation to some extent and clarification of expectations with regard to what is and what is not a legitimate expectation of what your attorney can do could conceivably reduce the number of complaints that we get that at the end of the day end up costing resources but don't result in any measurable improvement in public protection.
Well, I see several hands up, but I can't help but to jump in, Arnie, because it's not exactly what you're talking about. But for me, it's my personal view that this is a key metric for effectiveness is recidivism. We have a very high recidivism rate in our discipline system. So that means we're cycling through the same people more than once. That's not, to me, that's ineffective, right? And it's also showing that first interaction they're having with us, whatever we're doing or not doing, it's not effective. And so when you spoke, I think you were thinking further upstream to prevent maybe that first contact with the discipline system. But I think about a construct where your first contact is the last contact, right? So that we don't see people coming back.
So, and then Leah, to that point, that's one of the things that the probation redesign program is working on, is getting back or getting into evidence-based practices and figuring out ways to reduce recidivism, giving a little bit more flexibility to those handling the cases in order to tailor those programs specific to the individual needs of the probationers. So I think, Arnie, we're certainly taking steps in that. I think there's a lot of work to be done, but I think that at least for myself, those are incredible ideas, and we need to work on making sure that our stakeholders know what is already in the works, what we have been doing, and then ways we can increase or decrease recidivism. All right, let's see, Mark Tony.
I just briefly want to really support Arnie's point about part of effectiveness is greater compliance. Less complaints, but less complaints that's reflected by greater compliance by attorneys, whether it's because they got the fear of God put into them because they're really going to be disciplined seriously, quickly, with certainty. All right, those are some of the factors that are supposed to affect people's compliance in general. And rather than, the type of thing where, it's, people are in that, what do you call that? That commuter lane, because the chances of getting caught are just so small. So anyway, it's just, I completely support Arnie's point about how do we reduce the complaints and increase compliance.
Thank you, Mark Tony. Move on to Mark Broughton.
Thanks, Brandon. And I know you and I sit on that little subcommittee where we're looking at the issue of recidivism, which to me is a little bit different issue than what we're talking about here. But this whole thing just perplexes me. And it has the whole time I've been on here, this 180-day arbitrary number that we've been dealing with for all these years. And I guess I would ask Dag or Leah or somebody, is that what the legislature is looking for? Are they looking for a number, a measure, whether it's 180 days or 6 months or something, that all these cases are going to be resolved within that period of time frame? To me, it's much more complicated than that. For example, if an attorney is taking money out of a client's trust account, I think that case ought to be settled in 30 days, right away, if there's some sort of theft going on. Or if somebody, if attorney is convicted of a felony, right away, take action on these people, as opposed to somebody where there's a complaint filed that says the attorney isn't returning my phone calls, or I haven't got the results that I think are appropriate, or something along those lines. So there's a function in terms of the time that these cases are resolved, between the seriousness of those cases and the simpleness of those cases. I just don't know if in 180 day or any sort of number is the appropriate measure at all. We have gone a long way since I've been on the board in defining the types of cases. I don't recall us having P1, 2, 3, and 4 and those types of things, 4 or 5 years ago. That's something that has been developed, and we've sort of marshaled resources along the way to those things. But I really have a hard time with trying to come up with a time frame that fits all cases. I think we have to define maybe the types of cases themselves and say that they will be treated in different manners. Another way to think about it would be, to me, is you define exceptions. So for example, in the criminal arena, we have all of these speedy trial rules that things are supposed to be taken, within certain timeframes. 2 days within filing of the complaint, 10 days within a preliminary hearing, or 60 days, and so forth and so on. There's so many exceptions that those things almost never apply. Another thing that I look at is that when you look at timeframes, there's that initial, the complaint comes in, and then there's a determination about what to do with that case. Many of them are resolved without going to trial. I'd like to know how many of the cases actually go to trial, and is there a specific time frame that goes, like in the criminal context, speedy trial rights, 60 days between arraignment on the information and trial. Is there a similar type of time frame that applies to cases when the petition gets filed with the court? So to me, I just don't think that a time frame is what we ought to be looking at. It should be more along the lines of the type of case that we're dealing with, and how we resolve those cases. Those are just my thoughts.
I don't know if you want to respond, Doug, but I do see this as our opportunity, Mark, to suggest just that. I don't believe we're going to be able to get away from a time frame altogether, and nor do I know that we should, but I do believe we could put forward, for example, timeframes by the prioritization scheme that you referenced. It's an opportunity to put forward multiple different timeframes to take advantage of the complex designation, for example, as well. So I think we'll be able to do what you're suggesting.
Another thing I wanted to mention too is that I don't know if maybe Melanie can address this or somebody, if COVID has had any impact on the court and how fast these things get resolved. I can tell you, and I'm sure Brandon will agree with me, that in the criminal context, you can just throw all of the speedy trial rights out the window. There are guys that are sitting in there and sitting in jail for over 2 years, 2.5 years. I got a guy that's been in there 3 years, and they constantly have these emergency orders that trump any speedy trial rights. So I'm just wondering if we need to incorporate something like that into our thoughts in this regard, because I don't see the effect of COVID going away anytime soon.
All right, looks like Melanie Lawrence is available here to answer questions. So Melanie, you want to take a stab at Mark's questions?
I think Melanie Shelby has had her hand up, Brandon, for a while.
Okay. Well, Melanie Shelby, are you okay having Melanie Lawrence respond to Broughton's questions?
I am. Thank you.
Great, thanks.
Sure. So, well, a couple of things, a couple of reactions I have. One thing, I mean, I think with regard to the State Bar Court and the issue of COVID and the impact, I mean, I think definitely for, I would say at least 6 months or so, there was probably a significant impact in that. I mean, basically most cases were abated and not moving forward for trial or on appeal, et cetera. You know, we've gotten to a place in the past many months where those cases are moving now. The court is doing remote trials. And so for the most part, those cases are moving. I mean, I think where you continue to see the impact still related to COVID is in our ability, OCTC's ability to secure some of the evidence that we need. So for example, there are still courts out there where we are really struggling to get subpoenaed court records from. And for a while, banks were also slow. And the reality is, for some period of time, respondents were slow to respond to us. Some of them had left their offices and their records and had not returned for some time. But we're seeing a bit of a thawing when it comes to that, still some struggles. But you know, one thing that comes to mind for me too in your comments is thinking about effectiveness. And, you know, we talk a lot about effectiveness of the discipline system, really in terms of primarily OCTC. But the reality is that we're not the entirety of the discipline system. And so, for example, the State Bar Court plays a significant role in it. And, you know, my understanding, for example, of State Bar Court timelines is when we file cases, the court has some internal timelines. I don't think that they're set in any kind of statute. Somebody can tell me if I'm wrong. But to set cases for trial within 4 months of the notice of disciplinary charges being filed. Now, the thing about that, and thinking about your point, Trustee Broughton, about how we treat certain cases, is that the State Bar Court treats all cases the same for the most part when you're talking about original notice of disciplinary charges. So cases are set on that 4-month timeline, whether you're talking about the misappropriation case or you're talking about the complaints related to failures to perform, et cetera. And so that's something to think about too, when you're talking about prioritizing and trying to resolve cases more quickly. It's more than just OCTC. There are other players out there to think about.
All right, great. Thank you, Ms. Lawrence. Melanie Shelby.
Thank you. A couple of thoughts. I was trying to understand the course of this conversation. And I say that because as I look at kind of the goal, which I believe is, you know, identifying the best approach for developing new case processing standards and establishing criteria, with the thought that we have a new
chief trial counsel who will be coming on. I feel this conversation is a little premature, particularly if I heard correctly that October the 31st of next year is when we have a deadline to meet, and really it's in the spring where things need to start transpiring. And when I think about the ability of our new trial counsel to lead this conversation in an effort to address outstanding issues while also building relationships in the process and understanding that his confirmation is the ultimate goal, I feel like there's a real clear voice that should be guiding this conversation and some fresh eyes that get to come because so many of you have been engaged in this for so long. That's kind of like my overarching comment. The other piece is where have conversation with legislative staff been, and if they've been incomplete, and I kind of raised this in audit committee, and so I'm glad that we're dealing with this now, but if they have denied it, then I think it becomes, again, even premature for us to kind of define something. Unfortunately, compliance is compliance right now, right? The 180 days is the 180 days, and we may choose to provide some other insight, but we have to comply before we can do something different. I mean, that would be the prism in which I would see that under. So that was probably some comments and some questions all mixed together.
So I think it's important to clarify the timeline. The fee bill provides an October deadline for this effort. But if we waited until October of 2022 to submit our proposal, it would not be, if approved, it would not be reflected in the 2023 fee bill. We would have to wait an entire another year until 2024. And that does not seem prudent to me. I think to our team to wait. So the idea is that we will have a proposal for the auditor to consider in the spring. So that will require us not to start in the spring, but to have a proposal. I wholeheartedly agree with you that Mr. Cardona needs to be part of this. Part of what we're doing today is bringing it forward because at our last meeting, we relayed the proposal that we were going to submit to the legislature. This is a follow-up to say it didn't make it into the bill. However, and this really is a testament to the good work and collaboration that we engaged in with Assembly Judiciary Committee staff primarily. The bill does provide a pathway for new case processing standards to be developed. So what we submitted was sort of not wholeheartedly embraced, but where we are now is we've worked with them and we've created an opportunity or a pathway to develop a new standard. So I do believe it needs to be accelerated in order for us to take advantage of a potential January 1, 2023 implementation date. But as soon as Mr. Cardona is here, we will engage him in the work and he'll be part of the team. So I don't know, if you feel like that's responsive, but that is where we are. And then just to reiterate in terms of ledge staff, the fee bill outlines several different components to the case processing standard development effort. Some of those are outlined I think all of them in the written agenda item. We're focusing in this PowerPoint on some, but it outlines goals that we are to take into account. It outlines factors. It outlines a need to take a look at other jurisdictions and what they do, best practices to review prior LAO and auditor feedback. And we intend to comply with all of that and demonstrate our willingness, not just to partner, but to take their lead in some ways on these standards. So I just want to assure you that the partnership is there. We're going to be compliant, but I do believe we need to accelerate the timeline from what's in the bill.
No, and I appreciate that. What I was saying, and maybe it got missed in articulation, is understanding that October is the deadline. I just feel like this conversation is a bit premature if we've got a new OTC, the acronyms, but with George coming on board on October the 4th, I believe, or in early October, I feel like this is probably a conversation for a future RAD meeting because I'm confident he is aware of what sits in front of him immediately. So that was my thought.
Definitely. All right, Sean.
Yeah, so my only thought on this is in the metrics. I think we should consider giving them different the metric that we can meet with the current resources and the metric that we would prefer and could achieve with additional resources. I mean, we know from the, I forget the exact name, but the study that was done several years ago determined that we needed about 40 more positions than the legislature has provided funding for to meet the 180-day standard. And the auditor suggested that we, I'm not entirely sure what the auditor was suggesting, but I think they suggested that perhaps that's stale and that we should work to come up with a fact-based case for increased funding. And so I think that we ought to try to weave that into this discussion, because there's no doubt in my mind that we have a resource issue. And as has been discussed in the special audit committee, someone calculated, and it sounds right to me, that if you take account of inflation, the state bar's overall budget has declined 50% in actual purchasing power. But the caseload hasn't gone down. So, but we need to look at that systematically and not just assert that we lack the resources. But I think under the auditor's recommendations, we need to really do a study like we did before, or something else to really quantify the need.
Great, thank you, Sean. And before we get too far afield from Melanie Shelby's comments, see that George Cardona is watching our meeting. So hello, George. Dad, could you promote Mr. Cardona to panelist?
Certainly.
And not to put him on the spot, but just to see if he has any words of insider wisdom for was it pre October 4th start date?
Gotta love public comment, Mr. Chairman.
And Mr. Cardona, you are in the house.
Hi, I just wanted to say hello. I did call in so I could listen in and hear what's going on, since, as you've noted, it will play a significant role once I get there. Just to respond to Ms. Shelby's comments, the conversation so far has been very helpful to me in terms of understanding what everybody's looking for and where it's going. I do intend to turn to this when I get there. It's one of the first things on my list, is try to figure out, what the office should be doing and how best to measure that. So the conversation's been helpful, at least to me.
All right, welcome, George. Hopefully it hasn't been too scary here. Let's see, going on to Mark Broughton. Oh, Mark, you're muted here.
Oh, sorry. It's going to take Mr. Cardona a little bit of time to get up to speed to see what's going on in that office. And I do think, I agree with Sean that caseloads have a lot to do with the ability of cases to move quickly through the system. I don't know, maybe this is putting Melanie Lawrence a little bit on the spot, but I'd like to know her thoughts on these issues. And she's been in the trenches, just as a general way. How long does she think simple cases should take, or how long does she think complex cases should take? Just something so we have an idea based on somebody who's been working on these cases for the last great number of years.
Sure. Well, it's still a hard question for me to answer, honestly. I do think, to everyone's point, actually, it is driven by resources. And something that we're going to be talking about in a little bit is this issue of more complex cases. So, I mean, what we know is in our P2 cases, so those really would be the more simple cases that we have. Oftentimes which resolve, without going to pre-filing or filing, realistically, properly resourced, we can move those within, anywhere from 3 to 4 months. Now, the issue becomes in these more challenging cases, where complexity can be about a challenging set of facts, like if you're dealing with a fraud scheme, for example. But it can also be that there's something inherent about these cases that oftentimes are not within OCTC's control, but upon which we have to rely. So for example, where we're talking about immigration cases, if we have to get an immigration file, it often takes upwards of 6 months just to get the immigration file. So we're already well past the 180 days. Now, those might not necessarily be challenging cases in and of themselves, depending on what the complaint is. But if we need that entire file, it's going to take us longer to get it. Other issues that come into play, for example, that impact our ability to move cases is the number of complaints that we have against a particular respondent. So, you know, sometimes we get multiple complaints over a period of time against a respondent. And we try to group those cases to the extent possible in terms of how we move them through the system. And the reason for that is just, you know, a due process for the respondent, because if we piecemeal cases going to state bar court, there's a perception at times that we're piling on because the potential exists that if someone is disciplined and then someone is disciplined again, when we could have potentially brought the cases together, that perhaps they're getting more disciplined than they should have. Other things that impact, and I know that we've talked about before, is that there are a number of things that are required in our process that count against our time. So for example, the ENEC process, we are required to offer an ENEC to respondents prior to filing a notice of disciplinary charges. Well, there are timelines set out in the rules in terms of how long they have to respond and then how long the court has to schedule. But frankly, in many, many instances, depending on the court's own resources and the court's calendar and the calendar of the parties, those cases don't necessarily get timely scheduled in terms of early neutral evaluation conferences. Sometimes there are multiple early neutral evaluation conferences. And during that time, all that time is counting in the 180-day process. Also keep in mind that we have to give the respondent attorney a summary of the allegations against them and an opportunity to respond in writing. And as you might imagine, oftentimes, particularly if it's not represented, that process can take some time. Sometimes people put their head in the sand. Sometimes people sort of trickle in terms of the responses that they give us. Sometimes they're unresponsive. So there are a number of these things that are not within our control, but that are built into the system that make it difficult to actually move some of these cases forward.
Melanie, that was terrific. And you've actually covered a fair amount of what was already scheduled for your presentation on the complex issues. Part of what I'm hearing, though, and I don't want to cut off what is a very helpful conversation, but part of what I'm hearing is that it may be premature for us to be having this conversation, at least at the level of detail that we're trying to have it. Trustee Duran, I see that your hand is raised. I'll step back.
Dad, you know, you can finish your point because I've got a little bit different thing to put on the table.
Okay,
so go ahead.
My point was actually that I thought that perhaps we could move on. I think that you know, this is some very good input. I appreciate your engaging with the topic, but perhaps we need to just simply commit to come back once our new CTC is in place and we've done a little bit more work on this and have converted some of the metrics into standards, some of the raw data into something that we would actually propose, and make it a little clearer what the timelines are for this.
And moving on, though, we would address the complex factors because that speaks to sort of the current paradigm and our need to comply with what's currently in place that several of you have spoken to.
So
right.
Let me just say that I'm sorry, go ahead, Brandon.
Go ahead, Ruben.
I mean, I agree that it probably is near time to move on, but I also think we should all recognize that what the legislature has done with SB 211 is it gave us an opportunity, is the way I've heard different people characterize it, and certainly that's a good way to look at it. But another way to look at it is they're sort of giving us a mandate. You know, we are the regulatory body. We are supposed to be the experts on our system. And so we have to not only take advantage of it, we have to maybe think out of the box a little bit. And so one of the things that occurred to me as I heard Melanie Lawrence talking was a day is not necessarily always a day. In other words, in my mind, there are different ways to characterize some of the things that Melanie gave examples of. For example, waiting for an immigration file from the immigration court and that taking 6 months. Well, that's not the same sort of day or that same sort of month as a month that we spend or our staff spends prosecuting a case, or the state bar court spends, doing settlement conferences. In other words, is there an opportunity for us to define in the statute or regulation different types of time periods so that some of the stuff doesn't actually get counted against us when we're looking at cradle to grave on cases? Just a weird idea.
No, I don't think that's weird at all. I think that's some good feedback for staff. All right, Arnie.
Just real quick, and I know we need to move on, but I have two real quick questions. One is, or one comment, one question. One, I would echo what Sean said about the potential inclusion of resource needs associated with addressing the metrics and the discipline system. I think that's critical. I think it's really important that we should try to do the two concurrently when we submit this to the legislature. And that leads to my question. My question is and this may not be the right item, but is there ever a time that actions that affect the bar are taken outside of the fee bill? So, for instance, if we're talking about budget issues and those sorts of things like that, or this could fold into something like that, could this be something that would be done so that we don't have to look at October of 31st necessarily as the operative date, and 2023 is the operative sort of time frame, but something that might allow us to do this even sooner?
Not that I'm aware of, no.
Okay. Maybe this will be a discussion that we could talk a little bit more about in our legislative liaison sort of meeting, but I'm good. Thank you.
All right. No, I think this has been a really valuable exercise and an incredible discussion. Certainly whenever people ask me for legal advice, I just think of every single time family members say, what about this? What about this? And my response usually is, it depends. And for non-practicing lawyers, I think that when you hear that it depends, it can be the most frustrating response that you can get when you're looking for a specific answer to a specific question. And I hope that in our formulating a response to the legislator that we do a little bit more than it depends, even though so much of it really does ride on factors outside of the state bar's control. But I think that staff has a really good handle on this, and I think some good directions. So Dad, can we move on to the next portion?
Sure. I'm going to pass it to Melanie to discuss the complex factors we've been looking at.
Sure, thanks. So I'll try not to take too much of your time. One of the reasons that we wanted to raise this was because, again, it's an opportunity. It's some helpful language in Senate Bill 211 that's helped clarify sort of this issue of complex cases. So I know it's in your agenda item. I just want to give you a brief description of what it is that we're talking about. And that is that there are two statutes in particular that speak to this issue of backlog, and they really are inconsistent with one another. So there's one particular statute that essentially says it's the goal of the state bar to resolve cases within 6 months. Within that statute, it also speaks to this idea of complex cases, and that the goal to resolve complex cases is 12 months. However, there is a conflicting statute that again says that the backlog goal for state bar cases is 6 months without any reference to this issue of complex. And this has been true for many, many years. And as a result, there was a time in OCTC some years ago where the office utilized this idea of complexing cases. The challenge with that was because of the competing statutes and the reports, the way that information is reported in the annual discipline report, even those cases that had been designated as complex were still being counted in the backlog, even if they had been resolved, let's say at the 8-month mark, they still counted in backlog because of the goal of resolving all of the cases in 6 months. So in Senate Bill 211, there's been some clarification on this topic in that we will be reporting on complex cases separately from all other cases, and that complex cases should be resolved within the 12-month period. So now the challenge with that, and the reason that we wanted to have a discussion with you today about it, is defining really what is complex. What is a complex case? And the word complex is a bit of a misnomer in that one can imagine a complex case being exactly what I mentioned earlier, a complicated fraud scheme, for example, that frankly could take years to resolve. But if what we're talking about is capturing those cases that there's something inherent about them that will often, if not always, take longer to resolve than 180 days, but perhaps within that 12-month range, then perhaps those should be considered complex as well, even though they don't necessarily fit the definition of what we might naturally assume is complex. So in thinking about this, and the reason why it's important today in particular to talk about it, is that the fee bill sets an expectation that we are going to be reporting on this complex designation, first of all, for the entirety of 2021. And then going forward. Now, the office has not used any kind of complex designation for many years. And so to actually define what we consider as complex now, we're going to have to do a little bit of retroactive application for. So in thinking about complexity of cases, or at least cases that inherently take more time, we have put together some factors. Now, I will tell you that this is something that the bar looked at probably 4 or 5 years ago as well, and in consultation with a number of staff members, tried to sort of put some definition around what complex cases are. We have gone back to those factors and sort of refined them. But this is sort of a living, breathing list that we would expect to potentially be modified along the way, because we really have to see how they play out. So, the initial thoughts, at least, in defining these cases that are going to take more time, we know, are cases where we are requesting bank records, for example, court records or federal records, and you see that the immigration matters is listed here. Also, again, what I talked about earlier, scheduling of early neutral evaluation conferences, because that is counting in that 180-day period. Consulting with an expert, including a forensic accountant, that oftentimes can take time just to secure one, just for them to actually get and go through the records and provide any meaningful analysis for us. Where a respondent retains counsel after we issue a notice of intent, and this is oftentimes where it triggers the ENEC. And oftentimes what we hear from defense counsel is, I need time. I need to review, the documents. I need to talk to my client. They have their own schedule, et cetera. So it takes time. Respondents with multiple complaints against them. This is something that I referred to earlier, and why these might take time to actually resolve. So these are some of the initial factors that we've thought of, and we're looking for input. And I also want to just note that the heading of the slide is defining case complexity in the near term. Now, the reason for that is because there is an expectation of a retroactive application from January 1st of 2021 through the rest of the year. We tried to think of factors that we could actually capture currently in our data set, so that we don't have to actually expend resources that we don't have, staff resources, to go back and working with a set of factors that are not easily identified in the current data set to actually then figure out which of those earlier cases would be designated as complex. So with our existing data set, for example, our ORIA can go in and determine which cases already in existence have been cases where we've subpoenaed bank records, or where there's been a scheduling of an early neutral evaluation conference, et cetera. So this is just the initial list that we are considering. And can you fast forward to the next slide, please, Dag? And so thinking then about more in terms of long-term and the cases that might also be included in such a list, but which are not so easily identifiable in the current data set, but which going forward we could identify, and then going forward staff, when cases are designated with this complex designation, could then actually input into the Odyssey case management system so that we could track it going forward. So you see a number of the factors that we've listed here: resolutions requiring coordination with basically other law enforcement agencies. There certainly are times, for example, when there are criminal agencies who are investigating a respondent who ask us not to actually proceed with a filing because it may interrupt their case, and we try to be mindful of that. Cases with a large number of witnesses, that's probably self-explanatory, but again, not easily captured in our current data set. Involving large amounts of documentary evidence that require summarization or review. This could be court records, bank records, etc. Unusual or complicated facts. This is probably actually a truly complex kind of case, if we think about it in its traditional sense. Cases in which respondents have made a misrepresentation during the investigation, because the fact of the matter is, where that happens, sometimes we end up going off into a direction that were it not for the misrepresentation, we would not have gone. And in fact, it takes us more time to come back and sort out what is actually going on in the case. So again, these are just some initial thoughts. They are not exclusive. And what we would want is to have sort of an opportunity to see how some of these things play out, perhaps add to them or subtract as necessary. But really, for the most part, today, we were interested in just raising it to you. And if you have any initial thoughts on sort of what the thought process is behind this and any of the factors themselves, we're interested in hearing those.
All right.
Just to clarify, because I just want to make sure, I think it's been confusing. For the remainder of 2021, we have to implement a complex designation. For the future, prospectively, as part of the new case processing standards, we have the ability to develop something more robust, as Melanie indicated. And again, Mr. Cardona would, of course, be 100% included in leading that effort. So sort of a two-step process.
All right, great. Mindful of the time, does anybody have any questions or comments? All right, seeing none. Anything else on this agenda item? All right, so I think what I'm hearing is that we really need to bring this back before a RAD. So I'm sure that this will probably make its way back on the RAD agenda in November. But great work by staff. Thank you for being responsive to the requests from our stakeholders, and we definitely look forward to providing the necessary information and our recommendations in this area. So thank you to everyone involved. Okay, going to update from State Bar Court. Dag, can you please identify if we need to promote someone, if they're on? I think it's Judges Purcell and McGill. Okay, see Judge McGill.
Hello.
Judge McGill, welcome. And then Judge Purcell. All right, we are on item F. So welcome Judges Purcell and McGill. Take it away.
Okay, I think
Yes,
Right.
oh, I'm sorry.
It's okay, Judge Purcell, please.
Okay, yeah, I'll just start it off real quickly. I'm not a presenter, but good afternoon. My name is Catherine Purcell. I'm the presiding judge of the State Bar Court. The court was asked to present today on some current projects. We appreciate this opportunity to tell you about two important projects and to answer any questions that you have. First, the State Bar Court is developing a robust self-help guide to be posted on the court's website. Judge McGill, who is a member of the review department and is spearheading this project, will talk about it and provide you an update. Second, the State Bar Court has recently developed and updated materials for appointing counsel in those cases where appointment is required. Erica Doherty is projects attorney for the court. She's done significant work on this project and she's going to walk you through it. In undertaking these projects, the State Bar Court seeks, as always, to make improvements to fulfill our mission, which is to hear and decide cases fairly, correctly, and efficiently for the protection of the public, the courts, and the legal profession. So with that, I'll turn the presentation over to Judge McGill and Erica Doherty. Thank you very much.
Thank you, Judge Purcell.
All right, good afternoon, everybody. I'll just be just a couple of minutes for my part of the presentation. Do we have the slides up?
Judge McGill, can you see them now? Can everyone else see
Yes,
them
I
now?
can, Erica, thank you, thank you. So turning to the next slide, the one that I'm responsible for, I'm going to give you some brief background and sort of update of what we're doing here at the State Bar Court regarding self-help materials for improper respondents. This idea really came as a genesis from the hearing judges, the trial judges, including myself when I was a trial judge back in 2015 and 2016, where we saw a need for improper respondents to have an easier way to understand the State Bar Court process. The best way to describe this is sort of akin to a way of helping to level the playing field a bit on knowledge of the process that occurs in State Bar Court that OCTC has that improper respondents do not have. They sometimes are under the impression they understand more than they do, but our process is a bit unique. Our rules are a bit unique. So sometimes they can be caught unawares of what they need to know. The project itself started back in March. And so we've been working on this for about 6 months. It's a group effort involving all 8 of the judges and including also our court counsels. So as you can see here on the slide, the guide has been designed to give the attorneys a basic understanding of the process, particularly an overview of each of the main players in the process, the State Bar itself, OCTC, the court, and also the Office of Probation that usually works with people who wind up with reprovals or actual discipline in completing their probation terms. The guide also includes relevant authorities, including the rules, regulations, and case law, and also goes through different stages of the disciplinary process, from investigation all the way through to the conclusion of the review process. Also rules for particular types of cases. For example, attorneys sometimes are a bit confused about what we call our J cases. Those are where discipline has been imposed in another jurisdiction. And then pursuant to Business and Professions Code 6049.1, we look to see what sort of similar, based on the misconduct, what sort of discipline we need to impose in California. And a lot of times attorneys get a bit confused. They think that this is an opportunity for them to relitigate the circumstances of what caused the discipline in the other jurisdiction. And of course, that is not allowed pursuant to the State Bar statute, pursuant to the Business and Professions Code. And so this is a way of sort of educating them about what is going to be covered in their cases and what is also not going to be covered in their cases. And finally, there's an overview of the disciplinary standards that we look at. Each type of violation, whether it be a rule violation or it be a provision of the State Bar Act, those are assigned disciplinary standards with a range of discipline, which is the presumed sanction that starts sort of the final disciplinary analysis, including mitigation and aggravation circumstances. And again, the improper respondent might not be aware of all the aspects of the various mitigation aggravation factors. For example, we notice a lot of times people come in and they are not really sure about what to do with their good character evidence. So there is kind of again, a general description about what the mitigation is and how it is best obtained. It is certainly not designed, and it certainly is not intended to provide attorneys with specific legal advice. It's merely a discussion of general concepts of disciplinary law here in California. At this point, we do have the initial draft of the document completed. It's approximately 35 pages at this point. We anticipate finalizing and publishing the document sometime at the end of the year, given our other work that we do here at the State Bar Court. So that is the conclusion of my presentation. I'll be happy to listen to any comments or take any questions that any of you might have.
All right, thank you, Judge McGill. Judge Purcell, does anybody have any questions or comments? I'm sorry, if we could go back to the, I just want to make sure I don't miss anybody. I can't see if anyone's raising their hands. Okay, there we go. All right, it looks like everyone was wowed by the presentation. So
thank you.
So thank you all. And we talked about it a little bit earlier in the board agenda, but this really is an important aspect of the Professor Robertson recommendations. And so we really want to thank State Bar Court for taking this on, for using your experience outside of the discipline process system through your work in the state, through the Superior Court system, and bring that expertise to this important topic. So thank you both for being willing to take it on.
And Brandon, thank you for your support of the project through the RAD.
Yes.
Absolutely. Happy to help. All right. Thank you both.
Brandon, I'm sorry, Brandon. Before the judges jump off, may I make a quick observation? Yes. Obviously, thank you, Judge Purcell. Thank you, Judge McGill, for this important work and for explaining it to us. I think I want to say that I'm especially gratified that I feel like a dual purpose has been served here. Certainly for respondents who are going through the system, important for them to have the overview that you've given and maybe provide some preventative help, but also for legal consumers who are considering filing a complaint against a lawyer or wondering whether they should. The process that you've described in your self-help website, I think, is going to do a lot to educate the public. So thank you for that.
Thank you.
Thank you, Ruben.
All right, so we have reached the end.
Sorry, Brandon. Hi, Erica is now going to also present on the appointed.
Oh, yes.
The appointed counsel.
Yes.
Yes. Erica, please present on this then.
Thank you, Brandon, and thank you, Lisa. So very briefly, I want to just give an overview of the State Bar Court's use of appointed counsel and the authority under which appointed counsel is utilized. Appointed counsel has been used in the State Bar Court since prior to the current structure of the State Bar Court, which was established in 1988. And counsel are used in two case types, 6007 B1 and B3 cases. And those are cases that basically in some form deal with the capacity of the attorney. So B1 cases are where the licensee has asserted a claim of insanity or mental incompetence. And B3 cases are where the court is going to determine whether or not the licensee is unable to perform the duties of a lawyer competently or is unable to practice law without threat of harm to the clients or to the public in general. The ability for the court to appoint counsel in these case types is pursuant to the rules of procedure, which are adopted by the Board of Trustees, specifically Rule 5.174 and 5.192. These rules are relatively similar, and they provide that counsel will be provided without cost to the attorney. Counsel will be compensated for the reasonable expenses and fees for their work. The rate of compensation is set by the State Bar Court's Executive Committee, and the court will determine the reasonableness of counsel's fees and expenses in every case. To that end, the State Bar Court maintains a appointed counsel panel, and effective November 1st of 2020, State Bar Court Rule of Practice 1106 sets forth minimum qualifications for panelists. To apply to the panel, a panelist must submit a application, resume, writing sample, and letter of recommendation. And they also have to meet certain minimum qualifications. These include being admitted to the practice of law for 5 years in California, having no prior record of discipline, not being subject to current probation, and no pending disciplinary investigations in California, any other state, or any other court. They also must possess sufficient knowledge and skills, and those are demonstrated through the submission of their writing sample and letter of recommendation, as well as their resume. We also ask that the panelists let us know if they have malpractice insurance, and if they do have malpractice insurance, we ask that they provide a copy of their policy. Although we have the panel, the court has discretion to appoint anyone, including those who are not on the panel, as well as to remove someone from the panel if needed. Recently, we added an application to the State Bar Court's website. This is accessible through the current notices page of the State Bar Court website, and it just sets forth the basics for what is needed to apply to serve on the panel. And the application itself has some general information, and then again indicates that the applicant needs to submit their resume, writing sample, and a letter of recommendation. And a little bit more information regarding counsel appointments in general. So as was discussed earlier, effective May 5th of this year, through the end of this year, the executive committee temporarily increased the appointed counsel rate to $300 per hour from $100 per hour. And the appointed counsel are subject to prima facie allowances for specified services. As you can see, for pre-trial, it's 10 hours. Trial is the actual court time, and review department cases are 6 hours, and so on. If there's less time expended, only the time actually expended can be billed. And if more time is expended, the appointed counsel is required to submit justification for the additional hours spent to support their invoices. And that additional time is subject to approval by the judge who presided over the case. And appointments each year, it just depends basically on how many of these case types are filed. In 2020, there were 14 of these cases filed. And so far in 2021, there have been 14. So we're about on track from last year as well. And if anyone has any questions regarding the appointed counsel program, I'm happy to answer them, as well as I'm sure Judge McGill and Judge Purcell too. Thank you.
All right, does anybody have any questions for Erica?
I would just add, Brandon, if I could,
Yes.
that the increase in the appointed counsel fee, that was undertaken because we had, this is a mandatory appointment, and we had essentially no attorneys that were coming forth to do that. So in consultation with Donna at the time when she was interim director, we came up with this as an amount that would last for a period of time. And we have had now people that have applied and have been appointed. And we're hoping also very much so that our application process, which is more streamlined, thanks to Erica and other members of our court, is going to be helpful to maintain a good panel of attorneys. So just that little bit of background. Thank you.
Thank you. All right, any questions? All right, fantastic. Thank you to the three of you for presenting. And we always love hearing about the different areas of the bar, what you guys do on a daily basis, and how you help to protect the public through your unique role. So thank you so much.
Thank you, everyone, for your time.
All right, we've reached the end of our regular agenda. We do have an item in closed session. Just a time. Oh yeah, Lisa. Go ahead.
I just sent out the Zoom link for that.
All right, is everybody okay powering through? Do we need to take a break? What's the will? All right, so let's go ahead and then go into closed session. And then Sean, if it's okay with you, then we'll take our lunch break at that time. Or do you want us to come back and have a working lunch? I know we're a little bit over time here.
Maybe we can eat during the closed session.
Okay. Does that work for everybody? Do you need to take a couple of minutes to get some food? Why don't we take a 5-minute break? We'll reconvene into closed session with that link at 1:20. Okay, so for members of the public who are listening, we're going to go into closed session pursuant to Government Code Section 11126 sub A sub 1 and 11126 sub C sub 2. That will start at 1:20 and will take approximately 20 minutes. We'll then come back out into open session, report any reportable action, and then get into the regular Board of Trustees agenda at that point. So go ahead. We'll see all members in closed session at 1:20. Look for your email for the link. All right. Thank you. All right, welcome back. This is the Regulation and Discipline Committee. We're coming out of closed session. There's nothing to report out of closed session. And so we will adjourn the Regulation and Discipline meeting and turn it over to Chair Som Saleg for next steps.
All right.